You may proceed, sir. Would you like to reserve any time?
3 minutes, please. Morning, Your Honors. My name is Steve Barnes. I represent the estate of Now Red. We've submitted to the court respectfully that this case should be reversed and remanded to the trial court. As the trial court erred when it pronounced that Mr. Amon was a supervisor without engaging on proper analysis and weighing evidence that were not to be weighed in the summary judgment proceeding. We know that in the trial case,
That's a good question, Mr. Barnes. Is it
Yes,
your contention that Brace is vicariously liable for the gross negligence of Ammon?
yes, sir.
Is it supported anywhere in the case law?
I believe it is, Judge. I believe in the case that we cited in the brief of Morales versus Zenith, that is in our table of authorities and was omitted from the appellee's brief and not addressed, that addresses this issue. Now, in Morales, that was in the context of an insurance contract dispute, and it dealt with a workers' compensation policy that also had an employee liability section, which was known as gap insurance. Because there are exceptions to comp where that's not covered, and it's not addressed by the comp statute, so you can buy insurance to cover your employer liability. And in Morales, they looked at the right decision, WRIGHT, which is also cited in our table of authorities, not addressed by the appellate. And they pointed out the distinction. In Morales, they said, look, you can't have vicarious liability of the employer and coverage because you did not make an allegation that the employee was grossly negligent. You only alleged simple negligence. They contrasted that with Wright and pointed out that in Wright, there was an allegation of gross negligence against the employee. Therefore, that implicated vicarious liability, and there could be coverage under those circumstances. Now, I know we're dealing not with an insurance issue here, but a legal issue, and the trial court made that legal determination when it ruled on plaintiffs or appellee's defendant's motion to dismiss it from the case. The trial court made a legal determination, never receded, that we stated a cause of action both against Ammon for gross negligence and the employer for vicarious liability. That was the determination of the trial court.
So you're of the opinion that if Ammon is proven to be grossly negligent, that the comp immunity goes away for Brace?
I'm sorry to hear you.
If you're able to establish gross negligence by Ammon, then the comp immunity goes away for Brace?
Yes, sir.
What about the Boston versus Publix case? Doesn't it hold just the opposite?
Judge, I apologize. I thought I knew every single case that we had on this. You cited one that I don't know.
That's a case where there was an intentional tort alleged by an employee, and the court ultimately found in favor of Publix, and they were removed as a party, but the suit continued to proceed against the employee individually.
Yeah,
Gross negligence.
yeah, and if they're alleging intentional negligence, I can see that distinction. But in our facts, okay, I'm focusing on that part of the statute that is an exception in subsection 1 of 400.11, subsection 1, that says clearly, if an employee is grossly negligent, that exempts that claim from the comp statute. The vicarious liability exemption for an employer applies to those acts that are covered by the comp statute. So once the tortious conduct is removed from the comp statute, there's no longer protection for vicarious liability. That's why we alleged it the way we did. That's why the trial court made that determination and never receded from it. She started off her ruling on the summary judgment with the determination that Ammon was a supervisor. And the trial court had to do that because the court already determined as a matter of law and never receded, and the appellee did not cross appeal on the motion to dismiss. Issues not before the court. What is before the court, did the trial court make the proper determination and engage in the proper analysis that Ammon was a supervisor? Now,
Let me ask you that,
Yes, sir.
because, correct me if I'm wrong, I read your complaint. You may have had multiple complaints, but the operative complaint alleges Ammon is a foreman supervisor acting in the course and scope of his employment, correct?
Correct.
So how's that error to find that he is a supervisor?
Because the Hawkins versus Cordy case, which is a 30 CA case also cited in our brief, which cites to Madaffer, MADAFER, which is a second district court case, also cited in our table of authorities, holds that the reference or title of foreman or manager is insufficient on its own to conform immunity. What Hawkins says, and I'm going to quote, the question in every case is whether the employee is performing a prescriptive policy-making function or an operational implementation function. When the employee stands in the employer's shoes and acts in a policy-making function, immunity applies. We don't have that here. And I believe the facts of the record are clear. At worst, for the appellant, they're in dispute and it can't be decided as a matter of law. But the judge didn't even get there. She just pronounced that he was a supervisor, didn't engage in the Hawkins analysis to say, is this policy-making function or implementation function? And what the facts are, and we've cited them in the record, is that the employer Brace created safety protocols and policy. They expected their team leader and crew to follow. That's the record 792, the Menendez depot. The lead men, which was Amon, would implement, that's in the record, 792, Menendez deposition. And Amon was not viewed by his fellow coworkers as a boss. That's in the record, page 12.
Isn't there testimony in the record and also established by safety procedures that safety meetings were done? And then on this particular day, Amon did conduct one?
You can consider it a safety meeting because what happened is Mendez, who was supposed to be the team leader, was off shift because he had to go home, couldn't work overtime because of family. Amon was pulled from another part of the plant. He and Menendez got together and talked about it, and then Amon went to lead the crew on the floor.
Including your clients.
100%.
Okay, so my question is, I inferred from reading the record and the testimony is that it was up to Amon when and whether they entered into this area.
Pursuant to Brace's policies that he was bound to follow. Yes,
Well, but I understand the policies. I mean, that's like my notes here. That's a piece of paper. But Amon is there, and it was really up to him as to when and whether they entered this area. Correct or not?
correct and there's critical testimony on this in the record, because, and this is on the record 786, again, in the Menendez deposition, if the lead man, Amon, encounters a safety issue that the team can't address under the policy, Amon and the team have to stop and they have to call a supervisor to get them to dictate policy. That right there creates a question of fact as to what his role is. Is he a policymaker or is he implementing what the policymakers say? Someone who has to stop and make a call is not creating policy. He's waiting on to be told what to do so he can communicate it to his team.
Vis-a-vis Mr. Navarrete, who's on the job, it's day 4 for him, right?
Yes, sir.
I mean, how can he needs a supervisor?
He absolutely needs a team leader.
Wasn't Amon performing that role on that day?
He was performing his role as a supervisor to implement Brace policy. Yes, sir. He was not there to create policy or change policy, which is what I believe the Hawkins versus Forty test clearly says needs to apply in every case. And I don't believe the trial judge can get there if she conducts the analysis, but the error was she didn't conduct it. She didn't make any findings of policy versus implementation. That step was omitted. She just made a pronouncement. That was where the error was. Before our client, before the estate is barred under comp immunity, she at least needs to make that analysis. And that was decided as a matter of law without any findings in her oral pronouncement, which was attached to her written order. That's where the error in this case occurred.
This kind of sounds like a sovereign immunity waiver issue of discretionary versus operation.
To a degree, I can see the analogy.
Yeah,
I can see
maybe
it.
poor.
No, I see it. But Hawkins makes a very clear pronouncement that in every case that analysis has to be undertaken. And that wasn't done in this case, and that's where the error was committed.
So what is the relief you're asking? A new trial or a finding in your favor on the workers' comp issue?
So what I'm asking is for the order of summary judgment and the final judgment to the order granting the summary judgment to be reversed. In this
Which
case,
one, both of them?
Both of them,
Which
that's
one?
Hammond and Race. Because once she decided and pronounced that he was a supervisor without making the findings, there was no analysis of gross negligence. It reverted back to this is now covered under comp law and it's an intentional tort standard. So we never got to, she never got to the point of deciding the question, was there gross negligence and can Grace be vicariously liable?
Is your argument the proper procedures weren't followed, the proper analysis wasn't followed, and what's the relief that you are asking?
The relief I'm asking for is the order granting the summary judgment be reversed and the case be remanded for further proceedings for the court to engage in the proper determination in this one.
You want reversal with instruction?
Yes, sir.
Okay.
With the court to make the proper determinations on this issue. Shouldn't say proper determination, proper analysis.
I gotta ask this question
Yes,
still. Any of the cases you cited have the remand that you're looking for? Hawkins,
Well, Hawkins was a motion to dismiss case. And the trial court in Hawkins denied the opportunity to amend the complaint to make an allegation that the supervisor was implementing things and not setting policy. So that was a reversal of the order denying the motion to dismiss. And Judge, if there's nothing else, I'll reserve my time. I think it's just a very simple issue. That's why I'm not
you
using
have a full 5 minutes, so
Okay,
I'll get it to you.
thank you, Judge. Thank you, Your Honor.
You're welcome.
Good morning, sir.
Good morning, may it please the court. Forrest Andrews on behalf of the appellees. I'll begin with the argument with regard to Gray's summary judgment should be affirmed in its favor. There is no law whatsoever that supports the appellant's theory that an employer can be held vicariously liable for the gross negligence of an employee.
Am I reading the Boston versus Publix case correctly that says exactly what you just said?
You are, Your Honor. There's only two exceptions that allow an employer to be sued under 440.11. That is if they don't secure workers' compensation coverage,
If there's an intentional tort.
and if there's an
There's
intentional,
nothing in this record indicating there's an intentional tort in play, is there?
there is not. And in fact, the appellant has conceded throughout the case below, as well as in their briefs, that they're not pursuing an intentional tort. They never pled it. They never tried to establish an intentional tort, and it's undisputed that no intentional tort was committed in this case.
Well, but the statute seems to waive immunity for both entities, the employer and the employee. Correct me if I'm wrong, because you guys enumerated list for waiving comp immunity for an employer, which we just talked about, but it also talks about it's waived for a fellow employee if not acting within the furtherance of their business and did so willfully and wantonly or with gross negligence.
Correct. So the statute says when an employer can be held liable and when an employee.
So if you just allege vicarious liability, general negligence against Grace, but yet allege that Ammon was grossly negligent, you still have to prove those factors to prove his gross negligence. But where in the statute does it say if there is proof of Ammon's gross negligence that Grace is an employer, their liability, their work comp immunity is waived?
It doesn't. The statute is specific with regard to when an employer can be held negligent or liable, and when an employee, the gross negligence only applies to an employee, and it cannot be imputed to the employer. The case that's directly on point is Vallejos, and I'd just like to take a moment just to read it, because I think this really crystallizes the issue and hammers it home that this is not a viable theory against an employer. And this is located at page 551 of the opinion. The gross negligence and unrelated works exception found in section 440.11 1B2 are inapplicable to Vallejos' suit as a matter of law because the statute expressly states that the exceptions apply only to fellow employees. Vallejos does not cite any case law in support of imputation. The statute does not mention any imputation of liability onto the employer and specifically states that immunity includes vicarious liability. So even the plain language supports our position, as well as the Vallejos case. The third district decided that that's directly on point. There are no other cases that specifically address this issue. The Morales case and the Wright case say nothing about whether an employer can be held vicariously liable for the gross negligence of an employee. Those cases involved, they didn't reach the merits in those cases. Wright was a waiver issue where the insurance carrier refused to provide coverage for its insured, and then once it got sued, tried to assert workers' comp immunity as a defense, and the court said, no, you didn't cover your insured, we're not going to allow you to raise this defense, you're stopped from doing so. So there was a waiver or an estoppel. Morales, the exact same thing, you had a default judgment, so the courts never got to the merits of that issue. Vallejos is the only case that directly addresses this. I think there's another case where the appellant has relied on, but it applies in the public employer context. We were speaking about sovereign immunity a moment ago. In the public employment context under section 768.289, that specifically allows an employee, a public employee who is injured by a fellow employee to sue their public employer directly. That's only in the public employment context. There's no language that says that a private employee can sue their private employer. And Brace, of course, is a private employer. And so for those reasons, we believe that there is no viable argument or theory that Brace can be held liable for the gross negligence of an employee. And summary judgment should be affirmed on as to Brace. Turning to Randall Hammond. Mr. Hammond was the supervisor of the decedent at the time of this accident. And the court did engage, they did make findings as far as why she believed that Mr. Hammond was a supervisor. And I believe that's found at pages 1917 to 1922 and 1931 to 1934 of the record. After the second summary judgment hearing, and I know your honors have reviewed the transcripts, these were lengthy hearings in which all of these arguments were hashed out, and the trial court was very deliberate, asked important questions, clearly reviewed the record and was and understood what the law was and what the facts were, and ruled on the bench and said, here's my findings. This is why I believe that Randall Hammond was a supervisor. He was in charge of the crew that day. He directed them in order to fulfill his employer's purpose, which was to clean slag from the front of the unit. That is what a supervisor does. They direct employees, they make sure they're doing their job right, and that's exactly what Randall Hammond was doing. So there is no disputed facts there. And because he is a supervisor, he's entitled to the heightened standard that a supervisor is entitled to under the statute, which is culpable negligence, not gross negligence. That's reserved to co-employees. He's entitled to culpable negligence. There's no evidence that he acted in with culpable negligence. The appellant made no attempt to try to establish that below. So I think that is also undisputed. Now, to the extent that even if Randall Hammond was not a supervisor and he was just a co-employee, I don't believe that these facts rise to the level of gross negligence, and neither did the trial court. The court looked at various cases. A lot of cases were cited. One of the cases that was cited was the Klein case, where an employee was injured while using a meat tenderizing machine that wasn't bolted down. It had the safety warnings removed, and she wasn't trained to use it. And the court in that case held that that did not rise to the level of gross negligence. Those facts pale in comparison to what we have here. What we have here is Randall Hammond, who was not in charge of the gate opening and closing. He had no knowledge that the gate was going to be open at the time that he directed his crew to work in front of the gate. That was controlled solely by Tifa and the operator. And the operator never communicated to Hammond that it was going to be open. So we have a situation here where, based on the facts as presented to Hammond at the time, based on his knowledge, there was no danger and nothing was imminent at the time that he directed his crew to plan cleanup opportunities. And so for those reasons, Mr. Hammond is entitled to summary judgment as a supervisor or as a co-employee, because the undisputed material facts, they failed to establish a dispute. And
Nothing like this had ever happened before at that plant, is it?
it had not. And that is another factor. This has never happened over the many years that Brace has been working there. Even Tico, this is the Tico plant, even their employees testified that this has never happened. So I respectfully request, for those reasons, as well as the reasons raised in our brief, that the summary judgment orders be affirmed. Thank you.
Thank you, sir. Mr. Barnes.
Yes, sir. Thank you, Your Honor. As to the last one, I don't believe the issue of gross negligence is before the court because the trial court never got there. But if for some reason the panel believes it is, the record is replete with evidence of Mr. Ammon's gross negligence. He had a work order that told him there was a plug. He testified himself that if he knew there was a plug there, he knew there was imminent danger. He knew that was somewhere his men should not be. Menendez, the other team leader, said, if you put your crew in front of an open doghouse door under the rolling boiler, under those circumstances, you would have to consciously disregard their safety. That's in this record. I don't know how a trial judge looks at those disputed facts, weighs them, and arrives at the decision she does following the summary judgment standard. So I respectfully disagree on the gross negligence issue. Again, on the policy making, Hawkins is clear on what tests should be applied. And again, at best, there is conflicting evidence as to whether he is or is not a supervisor with policy making decision authority. That is not clear and should not have been decided as a matter of law. That's where the error was. We never get past that to any of the other issues because the only decision the trial court made on whether Brace can be sued for vicarious liability for punitive damages was the motion to dismiss when the trial court said, yes, that states a cause of action, and the appellees chose not to cross appeal that. So I don't believe that's before the court. The only issue that's here is the threshold issue. Did the trial court apply the correct analysis to determine he was a supervisor? Because until she gets to that and past it, you can't address gross negligence, the other issues. Once she determined he was a supervisor, incorrectly, respectfully, she then engages in an intentional poor analysis, which is the law under the code statute. So again, on this record, we believe she erred by improperly weighing evidence at a summary judgment hearing. And we also believe she did not apply the correct standard to get past the supervisor issue.
Thank you both. The horrific nature of this accident is not lost on the court. Thank you very much. All right, we'll move on to the third case. Ralph, hopefully I'm pronouncing this correctly, Tourette versus the estate of John T. Martin.